On July 1, the FTC withdrew its 2015 statement of enforcement principles regarding so-called unfair methods of competition under Section 5 of the FTC Act. On July 9, President Biden's executive order on competition called on the FTC to, quote, consider exercising the FTC statutory rulemaking authority to curtail the unfair use of non-compete clause and other clauses or agreements that may unfairly limit worker mobility. On September 15, the FTC changed the rules to allow interested persons of the public to submit petitions for the FTC's rulemaking authority. On December 6 and 7, the FTC and the DOJ will host a workshop to discuss competition in the labor market, where non-compete clause will be central elements of the discussion. What do these recent events signal? Well, it signals that the FTC is currently laying down the ground for an expanded version of the use of its rulemaking authority. The FTC breaks away from self-imposed limits, such as the 2015 enforcement statement, and opens the discussions on rulemaking with external inputs, the procedural rule changes, and the December workshop. The new FTC is committed to radically expand the ability of the agency to design ex-ante rules of competition rather than merely enforcing the current antitrust laws ex post. After all, the neo-brandism case for encompassing rulemaking authority of the FTC was made last year in 2020 article FTC Chair Lina Khan, then Columbia University Fellow, and CFPB Director Rory Chopra, then FTC Commissioner, wrote. Titled The Case for Unfair Method of Competition Rulemaking, the article can be seen as a guidebook for what Chair Khan intends to do. What she intends to do appears clearly to take antitrust away from the court because trials are, quote, extremely slow and prolonged, and to, quote, affirmatively design clear ex-ante rules of competition that companies have to abide by. In other words, antitrust will no longer be about an ex post liability regime, but more about an ex-ante regulatory regime, not about being a negative retrospective rules, the prohibition of anti-competitive conduct, but more about a positive prospective rules defining what is allowed and what is pro-competitive. The intentions well align with the European Commission's who proposed the Digital Market Act and those of the UK government who also proposed the Digital Market Unit within its competition watchdog. All these competition agencies aim at designing ex-ante rules of competition to limit the way companies can innovate and disrupt markets. The unintended consequences for consumers and innovation cannot be underestimated. In order to better understand the implications of the expansions of the FTC rulemaking authority, I'm delighted to have today with me two great experts who will provide their insights on this important question. Andrew Gavil is Professor of Law at Howard University and Senior Counsel at Correll & Moring. And Daniel Craig, who is Professor of Law at the University of Michigan and Counsel at Paul Weiss. Thank you, Andrew and Dan, for being with us today. Andrew, Dan, regarding the FTC's desire to expand its rulemaking authority through Section 5 of the FTC, a number of important questions are worth addressing. And perhaps the first one is, what about the legal basis of Section 5 of the FTC Act, and what's the legal basis for the FTC to engage in this rulemaking authority? Perhaps, Dan, can you just tell us a bit more about this legal basis? Because I think there's a history of controversies about it.
Yes, Aurelien, good morning. And you're right that whether or not the FTC has the authority to promulgate substantive rules enacting Section 5 of the FTC Act's prohibition on unfair methods of competition is unsettled. We don't know the answer to that firmly yet. So if you go back to 1914 and the creation of the FTC, FTC at that point only had the power to enforce unfair methods of competition as the standard. There was no consumer protection strand yet to the FTC's jurisdiction. And the Enabling Act gave the FTC in Section 6G the power to pass rules. Now, what wasn't clear, and for a long time the FTC did not try to do, is whether those included substantive rules or only procedural rules about how the FTC operated, which everyone agrees the FTC can pass. So in 1938, Congress added another strand of power to the FTC, which is the Wheeler-Lea amendments to the FTC Act, which gave the FTC the power to police against deceptive and unfair trade practices. And that's what sort of creates the consumer protection half of the FTC today as compared to the antitrust half, which is the unfair methods of competition half. So until the 1960s, the FTC really did not try to engage in substantive rulemaking. But in the 1960s, it began to do so. And the argument was just because we haven't done this before, it doesn't mean that we don't have the power under 6G to do so. That issue did go to the U.S. Court of Appeals for the D.C. Circuit in 1973 in a case called National Petroleum Refiners, where the court held that the FTC did have the substantive power to promulgate rules under Section 5. Now, what gets even more complicated, though, is that the Supreme Court never reached that issue. And then in 1975, Congress amended the procedures for the FTC to practice or to adopt substantive rules on consumer protection, deceptive, unfair trade practices. And so it heightened the requirements. It made it much more procedurally difficult for the FTC to adopt substantive rules on deceptive and unfair trade practices. But it also stated that this amendment didn't touch the FTC's power over rules on unfair methods of competition. Now, what does that mean? Does that mean that the Supreme Court effectively, Congress basically was endorsing the idea that the FTC does have sort of ordinary substantive rulemaking power under its unfair methods of competition? Or is it still the case that there's a good argument that that power is procedural only? So we don't know the answer to that question yet because the FTC just hasn't engaged in substantive rulemaking on unfair methods of competition. Now that, as you said, Chair Khan and perhaps other commissioners as well are interested in going that route, we will certainly have a test case in the courts to determine whether or not they have the legal authority to do that.
That's very interesting to also have this historical background because this debate is not new. It's a century old, I guess. Andy, what about this constitutional? Because as Dan very well explained, Supreme Court never expressed its opinion about this. So, what is there a constitutional boundaries about the FTC rulemaking authority? What's your take on that?
Well, first, thank you, Aurelien, for inviting me. It's a pleasure to be here with you and Dan. And just a disclaimer: anything I say today are just my own personal views. I think Dan would agree that we both need to say that. So before we get, I know you asked me about constitutional boundaries, but I'd like to sort of back up. Before we get to constitutional boundaries, there are arguments that are of the moment. There is more debate today on constitutional grounds regarding some administrative law issues that are broader than the FTC that may affect any litigation involving the FTC. And I think we'll want to get to that and talk about that. But just to pick up on a couple of the points that Dan made, as a statutory matter, in addition to National Petroleum, some of the folks discussing this issue have cited the Supreme Court's more recent decision in AMG Capital just from last term. And one of the questions, as a matter of reading the statute, is whether or not AMG Capital's approach to textualism, its approach to reading the FTC's other portions of the FTC statute would affect how it would read Section 6G on rulemaking. And I think there's two important components of how AMG approached it. It really had two different methodologies, if you will. First, it looked at text alone. And if you looked at the text of 6G, it is something more than there was present in AMG Capital. And you add it to the language that Congress added in 1975, seemingly acknowledging a scope of unfair method of competition rulemaking. And there's more text than there was to support the FTC's argument in AMG Capital. On the other hand, the second methodology that the court used in AMG Capital was kind of a compare and contrast, where they looked at how one part of the statute was written compared to another part of the statute. And I think that becomes the stronger test for the FTC in trying to support rulemaking under 6G, because the language of 6G is very sparse. It's basically one line and then an additional line that was added in 1975. But if you contrast that with the Magnuson-Moss procedures, they are very detailed on how rulemaking is to be done, what the penalties are for violating a rule that's properly adopted. And I think that portion of AMG could well play out as significant, because if you look at this comparison, you see a lot more detail, a lot more specificity about the scope of the FTC's unfair and deceptive acts and practices rulemaking authority as compared to its unfair methods of competition authority. One more point that I think is worth considering: most of the FTC's rules have actually been adopted pursuant to other statutes where Congress has directed it very specifically. Contact lens rule, for example, children's online privacy are two examples where Congress has directed them with very particular statutes to adopt rules. And I think, again, 6G, in contrast to those, shows that when Congress really wanted rulemaking, it specified and provided broader authority. And 6G does not stand up that well when you look at those statutes and when you look at the Magnuson-Moss provisions.
Very, very, very interesting. Let me quote the Section 6G, which authorized the FTC, quote, to make rules and regulations for the purpose of carrying out the provisions of this subchapter, end quote. I mean, that is very, very short. And yes, as you said, when you read the FTC Act, there's a lot of sections that are very, very detailed. And this section is very, very short. So we need, as you just expressed, we may need a congressional intent to have some rulemaking authority, because that is quite limited. But nevertheless, it looks like the FTC is embarking into at least an expanded version of rulemaking authority. We don't know if there might be subsequently some backlash from the courts. That's for years to come. But at least in the short term, it's very probable that once the next commissioner is appointed, there will be some rulemaking authority, even though the legal debate is not closed. And it's a very fascinating debate. But precisely, let's assume we engage in rulemaking authority and the FTC does so. There are two aspects that are perhaps clear subject to rulemaking authorities. One is non-compete clause and exclusionary contract. Just to stay on non-compete clause, it's a very interesting case, because we have President Biden's executive order that says that FTC is mandated to ban them, basically. And we have a number of states that prohibit them, the number of states that allow them. There's a question of federalism as well. What do you think, Dan, about this non-compete clause with this also federal aspect, which is interesting?
Yeah, Aurelien, I think it'd be a very interesting test case for the FTC. In fact, I think it'd be a unwise test case for them to start their process of enacting substantive antitrust rules, which they really have never done in their history, with something as far-reaching and a known category as covenants not to compete. We actually have 600 years of common law history of courts thinking through covenants not to compete and their enforceability. So long pre-Sherman Act, long pre the United States, we had British courts wrestling with covenants not to compete, and a very well-developed law, common law of covenants not to compete, to the place that many antitrust courts, which could consider covenants not to compete under Section 1 of the Sherman Act, have tended to defer to kind of the common law categories and the common law analysis of those covenants. And so whatever the right view of them is, and as you say, there are different views. Some states like California are very restrictive in terms of the enforceability of covenants not to compete. Other states are much more permissive. I think that the courts would take some umbrage if the FTC, with fairly tenuous authority to promulgate substantive rules, were to jump in and ban covenants not to compete comprehensively when there is such a long common law history of it. And remember, one of the things that's happening here is allocation of institutional authority. This is something the courts have thought is their province for a very long time. And so whatever the right reading of the statute is, I think that courts would be much more likely to say the FTC does not have this power if it were something as broad as touching something with such a long history as covenants not to compete. Now, I'm not suggesting that the FTC couldn't do something there. I just think that it'd be prudent to be targeted with it, as opposed to sort of displacing, as you say, federalism and state law, common law, with respect to something that's thought about and litigated about already a lot. So if they want to take a first step down the path of enacting substantive antitrust rules, they should really think about taking on something that's fairly narrow, fairly technical, and not something that the courts already comprehensively regulate.
Right. On these potential paragraph from the federal authority, because as Dana said, even the Congress hasn't regulated on non-compete clauses. So we have the FTC who may compete on non-compete clause, and also the economics tell us that there's some pro-competitive, some anti-competitive effect of non-compete clause. So what do you think about this? The need perhaps for having just a reasonableness criterion, which is, as Dan said, inspired by the common law principles.
So I think it's a really interesting question. I'm not sure I agree with Dan that preemption would be so much of a problem. In essence, any time the FTC has adopted any kind of rule, it potentially preempts state law, and its authority to deal with not just matters in commerce, but affecting commerce is clear. So I don't think the preemption is the issue. But I want to get at a different aspect of your question, Aurelien. And this goes to how really distinct unfair methods of competition are from unfair and deceptive acts and practices. So let's start from the basis that the FTC's authority for rulemaking for unfair and deceptive acts and practices is pretty well accepted. They haven't used it all that frequently, but that's not where the controversy is. It's more about whether the unfair methods of competition, the 6G authority, is sufficient. A rule based on non-competes in any way clearly involves elements of both, especially the way the issue has been looked at as a way of restricting relatively lower wage workers. And how you define unfair and deception may be the key to the foundation. So what the FTC might do for this is pursue under its well-established Magnuson-Moss procedures. But clearly, an unfair or deceptive act or practice can have competition consequences. And I think that you could get a rule that we might think of it as a hybrid rule in terms of its outcome that has both elements to it. But if they follow the procedures of Magnuson-Moss, they wouldn't have to test 6G for a non-compete clause rule, and they could pursue it. And I want to also point out that they've done a prior study. They did have a workshop on non-competes. As you mentioned, there's another labor market workshop that's coming up. So they are using their other powers, in essence, to do the research and lay a foundation for a rule. Now, one more point, which is the content of the rule could make all the difference. It might not necessarily be bright line for everyone. They might, as Dan has suggested, need to recognize that there are some areas where these are reasonable. The citizen petition that was filed on this was limited to employment. However, the 6B study that was released recently by the FTC of acquisition patterns by a small group of companies flagged the use of non-compete clauses in acquisition agreements. And that was an added concern that was not raised in the citizen petition. So how they will go about balancing the different types and the different economic settings, I think that's the devil in the details of a rule. I think it would be very problematic if they just said they are all unlawful. And I'm not so sure that they could defend that because, as Dan says, the restraint of trade language in Section 1 of the Sherman Act was adopted from the common law and goes back to covenants not to
Middle
compete.
Age. Yeah.
It's very old, and the test, the rule of reason, has its roots in that language, restraint of trade. It had to be a reasonable restraint of trade. If you took on an apprentice, you could say they can't compete with you after learning all of your recipes and tricks of the trade and your trade secrets and customers. You could restrict them afterwards. That has long been accepted as long as it was reasonable in scope. So I think that they will have to think through the circumstances under which defenses will be allowed. I think it would be very problematic to have a one-size-fits-all per se prohibition, and I don't think the record that they have would support that. But the record would support banning it in certain circumstances, and maybe what they would do is come up with, if certain factors are present, it is therefore banned. So it would be more like a presumption that it is unreasonable, or maybe a per se prohibition, but only if certain conditions are present. So it would be kind of a quasi per se.
It's interesting when you say like it might be a hybrid rule mixing consumer protection and antitrust competition. Also, just to revert to our previous questions about the legal basis, to secure perhaps a stronger legal basis, because the legal basis in terms of unfair methods of competition is quite weak, or at least not secured. So it might be interesting to see how. And also, I mean, I think it relates to the FTC's intent to bring together consumer protection and antitrust closer together with those ex-ante rules. So we will lead potentially to these hybrid rules of competition, but it's true that the reasonableness criterion cannot go away, and I think per se prohibitions is very unlikely to happen.
And on what you just said, Aurelien, just to sort of drive it home, one of Chair Khan's points, and I think it's a valid one, is that the Commission has siloed and separated consumer protection and competition far too much historically. And there are areas where they are interdependent and connected. And a rule like this might be a way to show that they shouldn't be thought of as so completely separate.
If I can just add on this point, though, I think, Andy, that may be right. But what's ironic about this, of course, is that Chair Khan, and the Democratic majority on the Commission, the first thing they did was withdraw their guidance on Section 5 and unfair methods of competition, precisely because it had a consumer welfare standard in it, right? And so it's a little bit odd to me to say our project is to dismantle the consumer welfare standard and then align antitrust and consumer protection. Optically, at least, that seems to me to be a little bit strange. So I'm not sure how far that goes.
So I think if I can add, Aurelien, to Dan's point, I agree with that, and I think that they also didn't like the rule of reason, which was mentioned, although I think they unfairly characterized it.
Which is very broad-based, by the way.
Yes, the statement said rule of reason like, and I think the intent was that there should be some kind of burden-shifting framework that would be used for Section 5. But a more focused point, I think if they want to go forward with rulemaking, they need to build a foundation, and a new foundation, whatever that new part is. If they don't like consumer welfare and rule of reason, I think they need to think through and adopt a new Section 5 statement. We may well see them going back and revisiting the unfairness statement, which has been around for quite some time. But there's no requirement of notice and comment for guidance, for policy statements. And I think it would be wise for them to build that foundation as a way to go forward with rulemaking, because I think Dan's point is well taken. Before you adopt a rule, you have to say what you think the scope of Section 5 really is.
We see a lot of withdrawal and rescind of policy guidance, but we don't see yet policy guidance. So sometimes it brings perhaps companies or even scholars in the dark. So yeah, we look forward for more guidance, but also antitrust and consumer protection can be related, but sometimes it's a different logic. It starts from market failure, right? The perception of market failure. Consumer protection is an ex-ante regulatory rule, whereas antitrust is very much exposed. And to bring that together is trying to perhaps bring together some opposites, isn't it? And I think that's part of the challenge of the FTC rulemaking authority to take antitrust perhaps away from the court, as some have written, take antitrust away from the court to have less numerous lawsuits and to lay down the regulators. Dan, do you want to comment on again, these intersections, or at least the goal of bringing together two different logics?
Yeah, and I agree that if we're going to have one FTC with these two different strands of authority, it does make sense that they think about them comprehensively. And for example, organizationally, the FTC consists of three organizational units, right? We have competition, we have consumer protection, we have economics, and economics is supposed to be in some sense the bridge between those other two units that sort of thinks about the comprehensive way in which markets function and generate the things that we want, which is competition, good prices for consumers, good wages for workers, innovation, quality, and so forth, right? So I do think those things are continuous. But I agree with you, Aurelien, that the modalities of how we think about antitrust, we're very ingrained in thinking about antitrust as kind of a rule of reason, which requires attention to facts. It's very inductive instead of deductive. Again, we have per se prohibitions, so we know what that's like for hardcore price fixing, for example. That's simply not allowed. But most antitrust, most Section 1 analysis, all of Section 2 analysis, and all merger analysis has tended to be very inductive and factually based. And the question is, can you really specify those kinds of things in rule-like form? It was interesting, in 1989, the American Bar Association had a study on the FTC and concluded that trying to enact rules, sort of hard and fast rules to govern competitive behavior under antitrust didn't make a lot of sense, precisely for this reason, which is that it's very factually based and circumstantial. And actually, I think that's a little bit overstated. I think there are, again, the per se rule is a good example of where we can be categorical. We don't permit cartels, like full stop. I also think sometimes the courts become categorical in saying there are safe harbors. So, for example, a firm that prices aggressively but above its cost is simply allowed to do that. So I think that some of antitrust law can be specified in a kind of bright line way. And I have ideas, of some things that I would personally be very comfortable with. For example, a company that participates in the standard setting organization and fails to disclose its patents. I think to me there should be a bright line thing. Like you participate in steering the standard towards your patents, and now you should not be allowed to charge a monopoly price for them. So I have no problem with the idea in principle that some aspects of antitrust could be specified in a bright line rule-like way. I just think that the bulk of it still needs to be kind of rule of reason most of the time, which is why rulemaking, I think, should be very targeted to particular industries or particular kinds of behaviors that are susceptible to this kind of ex-ante specification.
Yeah, that's a very, very interesting point, and it leads to perhaps the second rule that will perhaps that the FTC would be very keen to adopt is on exclusionary contract, where we precisely know from economics that there are a lot of pro-competitive, anti-competitive behavior, but the clear rules are very hard to define in this field. So what would it mean, perhaps, Andy, to have the FTC regulating ex-ante exclusionary contract if they want to engage in regulate, like these bright ex-ante rules about exclusionary contract, which sometimes is vertical restraints or things that are very ambiguous economically speaking? Is there a risk of over regulations or false positive?
Yes, and I think that's a much more difficult area to come up with a rule, because the context matters and the context can really vary. And that's something that the courts have done over time. On the other hand, I am sympathetic to the argument that the courts have made it far too difficult in some instances to prove cases under the current antitrust laws. Section 2, there's a reason there are very few cases. It is very, very hard to mount a Section 2 case. You're seeing the government facing it now. You can count on one hand, if you are trying to be the government, how many truly successful Section 2 cases there have been in the last 50 years. Not a lot. So I'm sympathetic to that. I wrote an article with Steve Solop recently talking about how we need to adjust our approach to assumptions and presumptions, particularly in Section 2, and how we're going to apply the rule of reason in Section 2 case. Having said that, I think a rule could not do much more than maybe, as I said earlier, state conditions under which there would be a presumption that something is an unfair method of competition. I think it would be very hard to specify per se, as the citizen petition was advocating. There's another aspect to all of this. When we talk about radical change, we have an economy that has relied on a certain set of rules that have developed over more than a generation. You can't suddenly change those rules. I mean, if you say exclusionary contracts defined broadly are all unlawful, every franchise arrangement would be unlawful. And many other kinds of supply arrangements and vertical arrangements would be unlawful. So I think that there is going to be a lot more resistance to trying to come up with a rule on exclusionary contracts, unless it borrows to some degree. It doesn't have to follow the case law, but it has to borrow to some degree from the case law to establish some kind of standard. So presumptions are not automatic, and the kinds of conditions under which anti-competitive conduct has occurred, that those get written into it. That's where I agree with Dan. The hostility to consumer welfare is a little bit overstated. Not a little bit, it's very much overstated. Economics must have a role to play. You can't just toss the whole system out. You need to think about the consequences, because you're talking about the economy. And rulemaking for the economy means you must think about its impact.
Right. Very, very interesting. I take from it that the rulemaking on exclusionary contract will be kind of codification of the case law, so that you write down the case law, and there will be some presumptions that will lead to some reverse burden of proof, so that there's a presumption of anti-competitive conduct that the companies may have to rebut, which would be, I think, very hard for some companies. Dan, what's your take on exclusionary contract as part of rulemaking authority?
Yeah, so I guess I want to disagree a little bit with Andy. I agree with most of what he said, but on the question of whether it's become too hard to win Section 2 cases, last year I put in some congressional testimony where I counted, just at the appellate court level, wins for plaintiffs in monopolization cases since the Microsoft case in 2001. And I got well over, one or two a year on average at the appellate level, wins for plaintiffs. So, whatever the optimal number is, I don't know. But I think there actually are many plaintiffs who are successful in bringing Section 2 cases today, and maybe not enough. But I just from where I sit, that's not an insurmountable bar. But that said, I agree with Andy in general that we need to be careful. I mean, I think for one, if the FTC's project is to get some rulemaking authority, overreaching early on, whether it's covenants not to compete or Section 2, is going to put their agenda back. Very much in the same way that in the 1970s and early 80s, the FTC was bringing not rulemaking but cases against various practices that were not illegal under the Sherman Act, but were said to be illegal under the sort of further reach of Section 5, and the courts largely shut them down. And then the FTC sort of went into remission for the better part of 30 or 40 years, not just even trying to bring those kinds of cases anymore. And so I think again, in terms of the long-term precedential effect, if the FTC comes in and really tries to dramatically change the law through rulemaking, again, whether or not they have the legal authority to do any rulemaking, I think it's much more likely that the courts will shut them down, and then that could deter any kind of a rulemaking agenda for a very long time to come. And so I do think, and I've written before, that some rulemaking in antitrust would be beneficial. And so I'm just reluctant to have them come in, and I think Andy's right, to sort of deviate very far from what the courts have said is the meaning of antitrust law. I think you could flesh some things out. I think you could think about particular industries or spaces in which sort of further clarity and some sort of further bright lines could be helpful. I think you get a much more receptive much more positive reception from the courts if they try to do that. And again, in terms of the long-term project of rulemaking, that would be much more successful.
That's very interesting, because there's this risk of judicial backlash in the medium and long term. Andy, do you want to?
Yeah, I want to pick up on that. So I think two things are very clear. It is very clear that Section 5 is supposed to be broader in reach than the Sherman Act and the Clayton Act. So that's pretty clear. I don't think anybody really debates that. But it is also clear, as Dan said, that when the FTC has been perceived as overreaching, there has been backlash from the two institutions that it ultimately has to face, Congress and the courts. So there is a political dimension to this that is quite significant and important, especially given who the judges are today, what the Supreme Court looks like today, and what Congress looks like. And I think that the political status is unstable. And it's really nice to get photographed with the president handing you a pen and encouraging you to go forth. That's great. But can he deliver in Congress if you go forward and you get your wings clipped by the courts? And that will be institutionally bad for the FTC. Now, and also, I know, and I know the pushback is that kind of attitude, that kind of caution has limited the FTC in the past. That has made it far too timid as an enforcer. That's the kind of argument that you would hear. And there's something to that, but there's also a reality element to it. And it will entirely depend on whether or not the courts and Congress are going to back up a more aggressive approach to rulemaking. And that is a very decisive and uncertain factor here. We said earlier that there's some perception that rulemaking will somehow avoid the courts and will be better than case-by-case litigation. Well, I'd say on the one hand, the advantage of rulemaking over case-by-case litigation is you can establish standards for issues that cut across many companies, something that you can't achieve with case-by-case litigation. On the other hand, it's an illusion to think it won't be tested in the courts. Any rule could be challenged in the courts, and rules don't enforce themselves. You have to bring enforcement actions to enforce your rules. So there is no circumventing the courts, and there is no short path. It's hard work to build a new antitrust, and it will have to be done by building a foundation and then taking steps that will not lead to backlash, whether they like it or not. You know, the first 6G, pure 6G that they try, better be a really good one, because otherwise you lose the authority and that's it.
Right. It's since you talk about the politics and the political support that is of course necessary, it's striking to see that the FTC doesn't have internal bipartisan support, right? So already in the FTC, there is no bipartisan support, or quite the contrary. The statements that we referred earlier were bipartisan statements, and the number of policy guidance were bipartisan policy guidance. So it's quite striking to rescind some bipartisan policy statements and now to have very split FTC, and then politically you have to convince the Congress and other political forces, but within the FTC, the support is not here, right?
Yeah, Aurelien, if we get to the point in the U.S. where guidelines change with every administration, and even the vertical guidelines, the FTC withdrew them. Department of Justice decided for now not to do that. If we can't continue to have some kind of internal consensus, that harms the economy, and it demotes us from having any leadership role in the world in terms of advocating for consensus competition policy. 3-2 votes one way can go 3-2 the other way. And one thing is certain: power will shift in Washington in the future. That will not be good for the institutions. It won't be good for antitrust. It won't be good for the economy. You can't have shifting standards because of the political divisions here in Washington. That concerns me a lot about the direction of the agencies.
Very interesting point. Dan, do you want?
I totally agree with that, and I think Andy's right that there's the political support that's necessary for effective antitrust enforcement to continue in the future depends upon it being perceived as being bipartisan and general. And I don't mean to say that as a criticism of anyone in particular, but obviously we're living in a time when there's a lot of bipartisan consensus that something needs to be done about antitrust, and you see, Senator Klobuchar and Senators Cotton, have together on a bill on tech acquisitions, which I think is a terrible idea, but that's another story. But you sort of see this bipartisanship, but that is really tenuous, which is it depends upon, I think, within the antitrust community displaying the same kind of effort to work together towards common solutions. And if we get an acrimonious FTC where it's just ribboned the entire time with division over its direction, we see the Justice Department and the FTC not even working on the same page. One agency operating under guidelines, the other agency not operating under guidelines. I think the courts are very unlikely to give a lot of deference to the agencies. And again, in the long run, you could go out there with some really aggressive rulemaking, make a big political statement, and find that the FTC is put back decades in terms of its prestige with the courts, its prestige with the American people, and that's not good for enforcement of antitrust law in the long run.
That's the pendulum is shifting too much and too quickly, perhaps. That's something. Since Andy, you referred to the international aspect, which is of course very important with international corporations. I mean, we cannot think of the Section 5 rulemaking authority of the FTC without thinking about also the European Commission's approach on the Digital Markets Act, but also the UK approach on the Digital Market Unit. So we kind of see these international initiatives of shifting ex-post judicial enforcement of antitrust rules toward a more ex-ante regulatory rules, because judicial enforcement is too long. And so with this reverse burden of proof, with this idea of regulating before even the harm ever occur, or we have evidence of harm, I mean, we may perhaps go toward what I call a precautionary antitrust, where this idea of precautionary principle, regulating before harm is ever occurred. And is this precautionary antitrust or precautionary view of competition rules not leading to the risk of some false positive over regulating? I mean, in the US, we have the Robinson Patent Act, which, I mean, is over-regulating the way supermarkets are competing on terms of price. So we have also these risks of not enforcing, because it's not enforceable, these rules, right? Is there a risk of having this shift of over-regulation?
But funny you mentioned the Robinson Patent Act, Aurelien, because in the late 1960s, that was the subject of a rulemaking that was a hybrid Clayton Act, FTC Section 5 rulemaking on men's clothing. And it's one of the few that you can actually find that tethered itself in some sense to 6G as a true unfair method of competition rulemaking. I am not philosophically opposed to the idea of ex-ante rulemaking. As I said earlier, I think the devil is in the details. And I think the question is whether or not you've got a record that really supports the kind of rules that you are considering. Europe and the UK have taken I would say, a much more systematic approach to laying the kind of foundation I mentioned earlier. I don't think the FTC in this country has the same scope of authority, especially with 3-2 votes, to develop a policy in the same way. I think you have much more consensus and agreement and political support behind some of the efforts in Europe and the UK. And they have certainly been the innovators in this area compared to where the US is. But I think our systems are different. And I think the cultural differences matter a lot when you talk about ex-ante regulation. There's definitely deep-seated resistance to that in the US that is very old and is going to play into any effort at rulemaking. And that's not the same in other areas of the world.
Dan, do you want to comment on the international aspect of this shift toward ex-ante rules of competition?
Yeah, I agree with Andy that we don't have the same culture for the president of the United States of kind of thinking through ex-ante regulation as to competition questions or even as to consumer protection issues. Frankly, we don't have GDPR at this. California has a version of it, but we don't have it nationally, and so we don't have the same culture. And it doesn't mean we can't move more in that direction. My biggest takeaway though is that the United States is a small c conservative country. We tend to be a place where where these kinds of shifts have to happen incrementally, and I don't think there's the widespread political support for becoming adopting sort of the European ex-ante regulatory approach suddenly or as to sweeping things. So if the FTC wants to move us in that direction, it's going to have to do so, I think, incrementally. And if it doesn't, I think it's not going to move us in that direction at all.
Yeah, that's the remaining spirit of the common law, which is still very present in the country. So we may go to the questions from the audience. There's one question which is slightly related with our topic, but I think interesting. Should the U.S. Be taking it in consideration other interests, such as national security, when implementing new competitive regulatory policies? You may think of the cybersecurity or things like that that are increasingly hot topics. Dan, do you want to have a say on?
Sure. So I think every country always has to take into account its own national security and its internal security in anything it regulates. And to me, this goes to a question that goes to the FTC's independence from the executive branch. And as some people may know, the question of whether the FTC will remain independent from the executive branch as a matter of constitutional law is very much in consideration today. The Supreme Court has been paring back in the last few years on agency independence, and the FTC may be in the same chopping block. But one thing about this question of national security is, well, who decides? The FTC doesn't have a mandate to decide national security questions. The executive branch clearly does. And so there's just an institutional question about coordination between independent agencies and the executive branch when it comes to national security. And look, there are times when we might prohibit a foreign firm from competing in the United States. Even that'd be good for competition, but because it'd be bad for national security. And I mean, I am not such a competition law purist that I would say, it's 1939 and we should be allowing, German firms to be making heavy investments in our national security infrastructure. Like, obviously there are moments when national security has to come first. I would just like that to be run through institutional channels where it's clear that the right decision makers who can take democratic responsibility for that are making the decisions.
A related questions that I may have when you say that is like, isn't it the White House Competition Council perhaps the ideal place to have these kind of interinstitutional, interdepartmental cooperations, because that may be perhaps the ideal venue? What do you?
Well, the president right now has invited the FTC chair to participate, but nominally can't require the FTC to do anything. I mean, that's the current constitutional landscape. You can't remove the FTC chair. Now, again, it's a practical matter. Of course, Chair Khan is going to cooperate. They're on the same page, but that's not a forever kind of thing, right? So I'm thinking about the long-term institutional structure here, which is to the extent we would want the FTC to be involved in considering national security, they have to be very closely coordinating with the executive branch, because they do not have the capacity, they don't have the legitimacy, they don't have the democratic responsibility for making decisions apart from their mandate, which is competition and consumer protection.
Or perhaps the DOJ, Antitrust Division, may be perhaps more aligned with.
But they don't have rulemaking authority. So
yeah,
again,
that's
if we're
true.
talking about rulemaking authority, I mean, that you could give the DOJ rulemaking authority, but I don't think they have it today.
Andy, perhaps another question that refers to your question of hybrid, between consumer protection and antitrust. How could a hybrid rulemaking authority work in practice? Can you perhaps give more details about these hybrid rules that the FTC could implement?
Sure. So when I refer to hybrid, I mean the substance could be hybrid, but I don't think you can have hybrid procedure. So a non-compete, for example, that followed the MAGMOS procedures as they have been revised would check the box and satisfy, for all intents and purposes, APA procedures and do more. So I think if you followed Magnus and Moss, but it had competition implications, it had competition values. For example, you write a rule that says we're writing this rule because current non-competes are unfair to blue-collar workers, but they also are impairing their mobility as laborers, and they're also impairing competition between the firms that are hiring them because they limit their mobility. So there's an example where the rule might have a rationale that is both fairness and competition. But if you followed the MAGMOS procedures, I wouldn't think that that would be a problem. The problem would be if you tried to follow notice and comment 6G APA approach, and you tried to include lots of traditionally unfair and deceptive acts and practices. I think that could be challenged on the ground that you should have followed Magnus and Moss, and you didn't.
Right. So not hybrid procedurally, but hybrid substantially.
Correct. Correct.
That makes sense.
And I think it would come out in the rationale for the rule. That's where you would see that it's meant to serve more than one goal.
Right. Right. Listen, I've learned so much. It was a great discussion. Thank you both for trying to decipher this complex topic of Section 5 and rulemaking authority, which I'm sure over the next few weeks, the next few months, gonna keep us very busy. Thank you very much. It was a great debate, and let's keep tuned for our next dynamic antitrust series. Thank you.
Thank you, Aurelien.